It's hard to overstate the importance of proper resolution techniques when it comes to Medicare secondary payer compliance and dealing with Medicare conditional payments, because failures to properly resolve these types of obligations can result in federal action. So understanding this is critical. The Medicare Secondary Payer Act is a very large statute, but if you boil it down, it creates obligations for personal injury recoveries that are determined by whether it's post-settlement or pre-settlement. The discussion today is going to be centered around obligations that arise pre-settlement. So those are conditional payments that Medicare has made when someone is injured and there is not a payment by a liability or third party insurer for those medical covered expenses. What's beyond today's presentation is obligations post-settlement. That's the Medicare set aside conundrum and question, and that's a whole nother presentation in and of itself. But just be aware that the Medicare Secondary Payer Act does have two aspects to it. What's also important to understand is Section 111 reporting, and we'll talk a little bit about what that is and why it's relevant and important. In a few moments, I'm going to talk about some of the obligations that you have as representing a personal injury plaintiff when it comes to Medicare and reporting. Now, the defense has a specific statutory reporting requirement called mandatory insurer reporting under Section 111. What this requires is the defendant to basically do a large data dump of information to Medicare anytime they settle a case with a Medicare beneficiary where the gross settlement is $750 or more. So pretty much every settlement has to be reported by the defense to Medicare, and it's reported by the RRE, which is the responsible reporting entity, which is typically the defendant, or they can hire a third party to report. What's important about this information is that when it's reported, if it's incorrect or inaccurate, it can cause a lot of problems for resolution when the case actually is settled and the plaintiff is trying to resolve the conditional payment. So working with the defense and understanding what is going to be reported, particularly ICD codes, particularly date of injury, those sorts of things, is really important to making sure ultimately that there's not problems on the back end. But just remember that all of this information is going to be reported by the defendant because it's required by law, and there are monetary penalties for failing to report. When it comes to resolving Medicare conditional payments, it's important to understand that all the parties have skin in the game. So a defendant, the Medicare beneficiary themselves, the plaintiff attorney, everyone has potential liability for failing to reimburse Medicare, meaning Medicare can choose who to go after. That's one of the reasons why a lot of times there is today language being included in releases by the defense that pertains to resolution of conditional payments, because they are concerned about their liability, and rightfully so. And as a plaintiff attorney or plaintiff paralegal, you should be concerned as well, because there's liability for making mistakes and failures in this area. So what I was talking about in terms of liability and risk in failing to properly resolve the Medicare secondary payer obligations, Medicare conditional payments, is that the government has become pretty aggressive about pursuing personal injury firms that fail to properly resolve Medicare conditional payments. And you'll see on this slide a list of different settlements that were as a result of failing to resolve a conditional payment or making mistakes. And it's important to understand there's a couple of mistakes that were made here, for example, that are opportunities to learn. So the settlement with Myers, Rodbell, and Rosenbaum was a situation where they had gotten preliminary information through a CPL, a conditional payment letter, which I'll talk about in a few moments, that Medicare issued, indicating that the conditional payment amount was fairly low, small, but when the case actually resolved and a final demand was issued, it was much larger. And the settlement had been made hinging upon this smaller amount that was due to Medicare. And ultimately, the mistake here was just simply that the portal and this conditional payment letter had indicated lower amounts of money were going to be due to Medicare, but that unfortunately doesn't bind Medicare. The only thing that binds Medicare is the final demand. So relying upon a conditional payment letter or something you see in the portal before Medicare has gotten the details of settlement isn't going to bind Medicare and can result in ultimately problems that occurred here. Another one of these settlements involved a case where one attorney referred the case to another attorney. The attorney who received the case didn't resolve the Medicare conditional payment. Medicare chose to go after the attorney who referred the case out, saying that it doesn't matter whether you are the referring attorney or the handling attorney, you have liability and responsibility. And it's important to note in these particular instances where the federal government has gone after personal injury firms, typically they're asking the firm to then take responsibility and have someone internally that deals with Medicare secondary payer issues and is trained on all of these issues, which if you take nothing away from today's presentation other than that, that's a win in my book, because you really need to make sure you understand the obligations and your team understands